Greetings, Madam Ida. We are the Legal Share Group, and today we will be presenting our group assignment.
Assalamualaikum and hello everyone. My name is Nur Asmina binti Rafai and my metric number is BB3310358. In this video, I will discuss scenario 1, which involves a forged check amounting to 150,000 ringgit Malaysia that was debited from Carol Ameng Trading's account. My discussion will focus on three issues. The first issue is whether Brilliant Bank Berhad is liable for honoring the forged check and debiting 150,000 ringgit Malaysia from Carol Ameng Trading's account. The relevant rule is found in Section 24 of the Bill of Exchange Act 1949, which provides that a forged signature is wholly inoperative. This means that a forged check does not constitute a valid mandate from the customer. The principle was established in United Asian Bank Berhad versus Tai Sun Heng Construction Sindiran Berhad, where the court held that a bank has no authority to debit a customer's account based on a forged signature. In addition, Section 73 subsection A provides a possible defense where the customer has negligently contributed to the forgery. The courts in Tai Hing Cotton Mill Ltd versus Liu Chong Hing Bank Ltd and Public Bank Berhad versus Tetuan Kumar Jaspal Kuah and Aisyah recognize that a bank may avoid liability if the customer's negligence substantially contribute to the forgery. The application is the 150,000 ringgit Malaysia was credited into Penny's account as a result of a forged check. Carol neither issued the check nor authorized the transfer of funds. Since the check was forged, the transaction was not supported by any valid authority. As the true owner of the funds, Carol may argue that Penny has no lawful basis to retain the money because it originated from an unauthorized transaction. Although Penny may claim that she received the funds in good faith alone may not be sufficient if she cannot establish a valid legal entitlement to the 150,000 ringgit Malaysia. In conclusion, Carol is likely entitled to recover the 150,000 ringgit from Penny unless Penny can establish a valid legal entitlement to the funds. The second issue is whether Vanguard Bank Berhad as the collecting banker is liable for collecting the proceeds of the forged check and crediting them into Penny's account. The relevant rule is found in Section 85 of the Bill of Exchange Act 1949. This provision protects a collecting banker if it acts for a customer in good faith and without negligence. The principle was recognized in Rubber Industry Replanting Board versus Hong Kong and Shanghai Banking Corporation and Assam Maju Enterprise versus Malayan Banking Berhad, where the courts emphasized that statutory protection will not apply if negligence can be established. The application is Vanguard Bank collected the proceeds of the check and credited 150,000 ringgit Malaysia into Penny's account. Although the bank was acting on behalf of its customer, the circumstances surrounding the transaction should have raised concern because the check was payable to cash. Yet, the proceeds were deposited directly into Penny's personal account. In addition, the amount involved was substantial. A prudent banker would be expected to exercise greater caution and make further inquiries before processing such a transaction. If Vanguard Bank failed to investigate suspicious circumstances or verify the legitimacy of the transaction, it may be regarded as having acted negligently and lost protection provided under Section 85. In conclusion, Vanguard Bank's liability depends on whether it can prove that it acted in good faith and without negligence. If negligence is established, it may lose the protection provided under Section 85 and be held liable for the loss suffered by Carol. Last but not least, the final issue is whether Carol is entitled to recover the 150,000 ringgit Malaysia that was credited into Penny's account. The relevant rule is Section 24 of the Bill of Exchange Act 1949, which provides that a forged signature is wholly inoperative. In United Asian Bank Berhad versus Tai Sun Heng Construction Sindiran Berhad, the court recognized that transactions arising from forged check may be challenged by the true owner of the funds. In addition, the law recognized the principle of conversion, which protects a person's property from being wrongfully dealt with by another person. The application is the 150,000 ringgit Malaysia was credited into Penny's account as a result of a forged check. Carol neither issued the check nor authorized the transfer of funds. Since the check was forged, the transaction was not supported by any valid authority. As the true owner of the funds, Carol may argue that Penny has no lawful basis to retain the money because it originated from an unauthorized transaction. Although Penny may claim that she received the funds in good faith alone may not be sufficient if she cannot establish a valid legal entitlement to the 150,000 ringgit nature. In conclusion, Carol is likely entitled to recover the 150,000 ringgit from Penny unless Penny can establish a valid legal entitlement to the funds.
Very good day, everyone. My name is Nadia Azariana binti Yusuf, and I will be discussing scenario 2, issue 1. The issue is whether the Carol Eming, as the owner of Your Restaurant, is liable for check number 223790 after Mamat, the manager of Your Restaurant, is changed the pay's name from Yami Sendirian Berhad to his own name without the Carol Eming knowledge and consent as a drawer. Under Section 3, Subsection 1 and Section 73, Subsection 1 of the Bills of Exchange Act 1949, a check is a bill of exchange payable on demand. Next, under Section 64, changing the payer's name is considered as a material alteration. Any material alteration made without the consent of all parties will render the check void against the drawer. This principle is supported by the case of Ong Eng Huat and another versus Arab Malaysian Finance Berhad 2003, where the court held that a bank may refuse the payment and alter a check. In this case, Carol Aming issued check number 223790 for 10,000 ringgit payable to Yami Sendiran Berhad. However, Mamat, as the manager of Your Restaurant, intercepted the check and altered the payer's name to his own name without Carol Aming's knowledge or consent. Since the alteration changed the legal effect of the check, it constitutes a material alteration under Section 64. Therefore, Carol Aming is discharged from liability because the check no longer reflects his original intention. So, in conclusion, Carol Aming is not liable for check number 223790, and Brilliant Bank cannot debit 10,000 ringgit from his account. Next, I will discuss scenario 2, issue 2. The issue is whether the Anas obtained a valid title to the check cross with not negotiable and the remedies that available to Carol Aming. According to Section 81 of the Bill of Exchange Act 1949, a person who receives a check crossed with not negotiable cannot obtain or transfer a better title than the person who transferred it. Although the check can still be transferred, it loses its negotiability. So this principle was established in the case of Wilson and Mason versus Pickering 1946, where the court held that a third party cannot obtain a better title than a person who has defective title. In Carol Aming case, Mamat fraudulently altered and transferred the check number 223790 for 10,000 ringgit to Anas. Although Anas accepted the check in good faith, he acquired a defective title because Mamat obtained the check through fraudulent action. Therefore, Anas cannot claim the ownership of the check proceed. So, in conclusion, Carol Aming may challenge Anas' entitlement and recover 10,000 ringgit if payment has already been made.
To see here whether Brilliant Bank is liable of Carol Aming for honoring the check number 223791 despite of forged signature and breach of closing instructions. So a check serves a customer mandate to the bank to pay a specific sum of money from the accounts. In Section 24 of Bills of Exchange Act, a forged or an unauthorized signature is wholly inoperative, means that the bank has no authority to debit the customer account unless the customer is stopped from setting up the forgery. However, in Section 73A, it provides provides protection to a paying bank if the customer's own negligence knowing to the forgery action, provided the bank pays in a good faith. In Section 78 of the Bills of Exchange Act, stated that a crossing is material part of the check and it is unlawful to obliterate or alter it except as authorized by the Act. And here are some cases. So, Mamat forged Carol's signature and presented it for a cash over the counter. So, Brilliant Bank as paying banker felt two things. So, under Section 24, the forged signature is inoperative, while the bank might argue that Carol was negligent in allowing Mamat to steal, but the bank officer, Mr. Marco, noticed the signature was suspicious, but they still proceed. So, by proceeding with the payment, the bank acted with gross negligence. So, Brilliant Bank is liable to Carol Laming for the 15,000 ringgit militia. The bank can't really rely on statutory protection as it failed to observe the crossing and ignore a signature that it already suspected to be forged. So, next issue is whether Nova Bank Berhad is liable for conversion regarding the check number 223790 and the statutory protection for collecting bankers. So, a collecting banker is the one who receives payment of a check for a customer. So, according to Section 85 of Bills of Exchange Act, a collecting banker is protected from liability for a conversion to the true owner if they act in good faith and without negligence. So, if a check is materially altered without the drawer's authority, the check is voided under the Section 64, subsection 1 of the Bills of Exchange Act. The importance of a collecting bank making proper inquiries was emphasized in the Rubber Industry Board and Hong Kong and Shanghai Bank Corporations. So in this case, the bank was held liable for conversion because it has failed to verify the identity and authority of a person opening an account with an account payee check. So if the alteration is not apparent, a holder is in due course might enforce payment under the Section 64, subsection 1, but bank must still prove it acted without negligence to be protected. Some amount here are to the check number 223790 from Yami Sundaram Berhad to his own name and then pass it to Anas, who deposit it at Nova Bank. So as the collecting bank, Nova Bank's liability depends on whether the alteration was detectable through some reasonable banking scrutiny. So if the alteration was truly living without any visible trace, the bank might argue that it acted without negligence. However, since the check was crossed as not negotiable, we can apply Section 81 of Bills of Exchange Act, where the person taking the check, Anas, cannot have a better title than the person from whom he took it, Mamat. And since Mamat had no title, due to the theft and alteration, Anas also has no title. If Nova Bank collected the proceeds from Anas without a proper verification of a third-party check, or if the alteration was detectable under any specialized equipment, the bank would be liable for the conversion to Carol Amin. So in conclusion, Nova Bank may be liable for conversion for the 10,000s. While the alteration is a defense, the bank must prove it followed the bank's standard banking practices and that there were no suspicious circumstances to warrant any further inquiry.